All right. I'm back, y'all. I had got my something had just went wrong with my thing. I had to sign out and sign back in. But I was just giving y'all an example, right? Giving y'all an illustration. All right. So to pick up where I left off at. All right. So what we're gonna assume is I'm gonna just use the real names. All right. So we're going to assume that Sally owns all of the shares of an entity. An entity hires Ernie to drive a truck. Ernie drives negligently and injures a third party, Tom. Ernie is liable to Tom for Tom's damages. Entity is liable to Tom because entity is Ernie's employer. This is the rule of respondent superior. Sally is not liable to Tom because entity has limited liability. All right. But that entity that has limited liability is set up as a C corporation. It is set up as a entity that's totally separate from Sally. All right. Corporations and LLCs have limited liability unless they elect not to have it. All right. So when you first set up your LLC, and if you just leave it in its default status and you do not elect or change for it to be totally separate from you, setting it up to be its own taxpayer, right? Then it does not have limited liability. All right. But if you do elect to have it, or when they elect to have it, it would be effect with the partnerships anyway, because partnerships do not have limited liability as well unless they elect to have it. Now, if they do choose to have it, they're called limited liability partnerships. All right. So limited partners have limited liability with respect to their limited partners, but not the general partners, unless they elect to have it with respect to their general partners. And if they choose to do so, then those entities are called limited liability limited partnerships. All right. But they have to set all of that up. This is where you have to have the knowledge on knowing how to deal with the IRS, knowing how to deal with the entity elections, and all of that type of information. All right. So, the previous illustration that I gave, if that entity had been a partnership that did not have limited liability, then the partners would have been personally liable for Tom's damages. All right. Now, an investor who is shielded from liability in her capacity as an investor may nevertheless be liable in some other capacity. For example, like if Sally drove the truck as well as owning the shares, then Sally would have been liable in her capacity as the tortfeasor. All right. All of these are, legal terms that you're going to have to get familiar with because we're about to start running these companies the right way. We've all been continuing to operate, as ourselves, unbeknownst to us. We thinking, okay, you know what? It's a lot of franchises and stuff. They got LLCs and they got the LLCs set up as C corporations, right? And then they go buy a McDonald's franchise, a Subway franchise. Unbeknownst to them, unbeknownst to them, right? Because that entity is a pass-through entity. All of the income is flowing through from the entity through to them. The company is not its own taxpayer. The person is attached to everything that the company does. It would be extremely, extremely difficult if there was some shark ass lawyers out there on a $1 million+ lawsuit on that ass. It would be extremely difficult to separate the person from the business because everything that this business is making, you putting it on your personal tax return. How can you win a case with some sharp ass lawyers proving that you're separate when you don't even have your company set up as you're separate? You understand what I'm saying? All of this information. This is why we have to study the law, for ourselves. Everybody can't afford these high ass lawyers, right? We all can. Most of us can't. So we winging it. We watching YouTube. We googling what we can, but None of the information is there. None of the steps will be there. That's why, a lot of these attorneys actually have patents on tax strategies, on asset protection, on strategies, on how to do these things, because there is no cookie cutter way. There is no place that you can go to find step by step instructions to do this thing the proper way. It took me 5 years, no cap. Once I decided that I wanted to incorporate my LLC, it took me literally 5 years. It took me about really longer than that, maybe about 6 or 7, because it took me about 3 or 4 years of just research, putting it all together, understanding it all. And then once I actually set it up, to get the experience, to go through the process, to, not know what I'm talking about, to not knowing how to sign my paperwork, to not knowing when to, you know, list my company as a LLC, or to not knowing when to check the box. Am I a corporation? Am I LLC? Am I a sole proprietor? I mean, there are so many things that you have to know. Even from um your accounting, how your accounting process, whether you're going to be a cash base accounting, or whether you're going to do accrual accounting. I mean, there's just so many things, whether you're going to be member managed or manager managed. I mean, there's so many ins and outs and curves, after you go fill out that paperwork, really once you begin to fill out that paperwork. But after that, if you want to do it the proper way, either you got to pay an expensive ass lawyer, or you have to put in a lot of hell of a time. And most people have done neither. So they just nilly willy freestyling it, and they cool with it. When, come on, man, this is where our generational wealth come in at, when we set these companies up right? This is where we have more financial freedom. This is where we pay less taxes, whether you know it or not. The IRS encourages tax avoidance. The IRS encourages you to be able to pay as less taxes as possible, but you have to have your entity structured properly, producing jobs, contributing to the economy, purchasing real estate. All of these things, the IRS provides tax incentives for you, and it's all legal. All right. So let's go ahead and wrap this up. All right. So limited liability assures that an investor, in its capacity as such, can lose only the money it has invested in the entity, right? Neither the entity nor its unpaid creditors has a claim against the investor for more. Limited liability is attractive to investors. Why? Because it enables them to receive the profits from a business they finance without having liability for damage the business may cause. In some circumstances, courts will disregard an entity that has limited liability and hold its investors liable. And see, this is where, you know the right tax strategies, um, forming your LLCs in states that are favorable to LLCs, because you don't have to form the LLCs in the state that you reside. There are a few states where it's, preferable, where a lot of attorneys recommend that you form your LLC. They're the best states for it. Tax, for asset protection. All right, I call it tap that ass, tax and asset protection. All right. So, again, in some of those circumstances, the courts will disregard the entity that has limited liabilities and will hold the investor liable. Now, the circumstances are those where the investors themselves has disregarded the entity. How can you disregard your own entity? By not setting it up properly, by not electing the proper election when you're setting it up. All right. They may have done so by doing what? Also by commingling the entity's funds with their own. How can you commingle the funds with your own? By not having separate bank accounts, by not paying separate taxes. How can that not be commingling? How can that not be? If whatever the business make is passing through to you, the individual. That means that you and the business is one and the same. All right. So commingling the entity's funds with your own, or not mentioning the entity when contracting with third parties, meaning just doing it on your own, or making decisions on the entity's behalf without following the procedures required for entity decision making. All right, and I'm gonna do a video on entity decision making too. That's gonna be coming up within the next video or two. All right. So entity disregard may occur under a variety of theories, including veil piercing, agency, single enterprise liability, and substantive consolidation. So we're gonna go over all of those in future episodes. Veil piercing being a very, very important one. Man, it's so much that we gotta learn, y'all. That's why I want y'all to tap in, continue to tap in, continue to watch, and take this from a different perspective. I'm giving it to y'all from a legal perspective. All right, I'm teaching this from a legal perspective. This is all for educational purposes. Also, um, what's the Copyright Act deal? The Copyright Act of for educational purposes under the Copyright Act of 1976. We got to get that in as well. Um, all right, so this was a pretty good series on limited liability. If you're catching this video, it was a video prior to this one that's on limited liability as well. Go catch that one. That's the first one. This one is piggybacking off of that one because my live stream ended up getting interrupted. All right, man, I'm finna get out of here. I'm out. Say y'all share the video, like the videos. I'm gonna get more graphics about liking and subscribing because this is streaming on 3 different platforms right now. Right now, it's streaming on my LLC Law Boss on Facebook. Go like and follow me there. It's also streaming on my Pickup Game University on Facebook. If you receive the invite, accept the invite, go like and follow that page, Pickup Game University. And also on my YouTube channel, I have a Pickup Game University YouTube channel. So go subscribe there as well. Click the notification bell so you can receive notifications whenever I go live. And I'm gonna add all of those graphics and stuff, in my videos. We're gonna get better and better at it. All right, I'm out. Peace. Y'all have a good weekend. Don't do too much. Shit, I'll be back throughout the weekend though. I'm gonna holler at y'all.